Your employer can't take back a job offer just because you use medical marijuana if it's legal in your state, right? That's what Brian Davis thought. He's an engineer and a registered medical marijuana patient. He was upfront about his use of medical marijuana, followed the rules, and assumed that meant he was protected. But he was wrong. His job offer was rescinded before he even started. And when it went to court, the judge said, yeah, the employer has the right to do that. So, what does Brian Davis's experience tell us about what could happen to employees who use medical marijuana for medical reasons? By the end of this video, you will have a clear understanding of how medical marijuana laws intersect with your employer's policies and how those laws play out for real at work. And stay with me until the end of this video because I'm going to walk you through the 5 things you really need to know, things that could make or break your next employment decision when it comes to medical marijuana. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. On this channel, I do more than give my legal opinion. I talk about real legal cases that demonstrate how the law might apply to your circumstances. Medicinal marijuana. It's definitely one of those topics that sparks a lot of debate. For some people, it's a lifeline. It offers relief to those who are dealing with some very serious, debilitating medical conditions. And for others, it's viewed as a legal headache with minimal value. But one thing's for sure, when medical marijuana shows up in the workplace, the legal implications are real. Now, just a quick note before we talk about the case we're reviewing today. We are talking about Brian Davis versus Higley Company, and that hasn't been fully decided yet. It's still pending in court, and I wanted to cover it anyway because it's a hot topic right now, and the judge's ruling so far is already shaping how medical marijuana is being treated at work. So whether you're an employee, a small business owner, or an HR professional, understanding how the law applies in these situations can make all the difference in how things play out. So let's break it down. Let's talk about what you need to know. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. And don't forget to like and subscribe. So this story starts in late January 2023 when the Albert M. Higley Company offered Brian Davis a job as a project engineer, but there was a catch. The offer was contingent on him passing a pre-employment drug test. The role itself wasn't considered safety sensitive. Actually, over 80% of the work that Brian was to perform was going to be in the office, and less than 20% involved being out in the field. So on February 2nd, 2023, after getting a job offer from Higley Company, Davis gave his notice and let his current employer know that he was moving on. Now, Davis had been dealing with some very serious anxiety and depression issues coupled with ADHD, and he was upfront with the company about his diagnosis and the medications he was prescribed, including medical marijuana. He even let them know he had a valid medical marijuana card. So Davis accepted the conditional offer and moved forward with completing the pre-employment drug test. Not long after, he even offered to sign an agreement saying he wouldn't use cannabis during work hours or at any time that might leave him impaired while on the job. But later that same day, the Higley Company sent an email saying they were rescinding the offer. They wrote, after careful consideration, this decision was made due to your drug screen and reported levels considered unsafe in our work environment per Pennsylvania law. Davis asked for a copy of his drug test results, but the Higley Company would not provide them. Instead, they referred him back to the testing provider, Mobile Medical Corporation, and the company stood by its decision to revoke the job offer. And so on November 14th, 2023, Brian Davis filed a lawsuit against the Higley Company. He claimed that taking back his job offer violated Pennsylvania's Medical Marijuana Act, a law that protects registered marijuana patients from being discriminated against just because they have a medical marijuana card. Davis also alleged disabilities discrimination under the Pennsylvania Human Relations Act, saying that the company failed to accommodate his medical condition. And he brought claims under the Americans with Disability Act, arguing that the company's actions went against federal disability rights. So, what he claimed was that the company didn't make reasonable accommodations for his disability. He said they never even tried to have a conversation with him about what kind of support he might need, something that's required under the Pennsylvania Human Relations Act. Hey, are you still watching? If you find this video helpful, please take a moment to like and subscribe. Your support really helps. Thanks. Okay, so before we talk more about this case, let's take a quick moment to talk about the Americans with Disability Act because it plays a big role in the case and helps to provide context regarding Brian's argument in the case. This is exactly where an employee's disability rights and a company's drug free workplace policies start to collide. So, to really understand what's going on, we need to really look at both of them. The Americans with Disability Act, or ADA for short, is a federal law that protects people with disabilities from being discriminated against at work. The law is designed to find a solution that makes sure that qualified individuals, people who could otherwise perform the duties of their job, have a fair shot at getting hired, keeping a job, and doing their work just like anyone else. But the ADA doesn't stop at just saying don't discriminate. It also says employers have to provide what's called reasonable accommodations. These are changes or adjustments to a job or work environment that helps someone with a disability to do their job effectively. Things like flexible schedules, modified duties, or technology that can assist an employee with performing their job responsibilities. Now, this is not about giving someone special treatment. It's about making sure they're not unfairly held back by a condition that they didn't choose. It's something that they have innately as a condition, an issue because they're alive, because they're a human being. It's not anything that they choose to seek out. So this isn't about special treatment, it's about reasonable treatment. This means that employers don't have to say yes to every request that's made by an employee, but they do have to at least try to find a solution. And the process of trying to identify a solution that would support the employee but be reasonable for the employer, not putting too much of a burden on the employer, that process is called the interactive process. And it's basically a good faith conversation between the employee and the employer to figure out what might work for both sides. So, in this case, the question becomes what happens when a person's medical treatment, like marijuana, is in conflict with those against a company's drug policy? That's where things get tricky. Now, just to clarify, the Pennsylvania Human Relations Act isn't an extension of the ADA, but it does work alongside it. While the ADA is a federal law, the PHRA is Pennsylvania's own anti discrimination law, and in many ways, it offers broader protections than the federal law. That means employees in Pennsylvania are protected under both state and federal law when it comes to disability rights. Hey, are you still watching? If you find this video helpful, please take a moment to like and subscribe. Your support really helps. Thanks. Okay, so let's talk a bit about how the Higley Company defended itself against this lawsuit filed by Brian Davis. The first thing the Higley Company did was to file a motion to dismiss. In simple terms, they argued that Davis didn't even have a valid legal claim, so there was no reason to move forward with a trial. It's likely that Brian Davis's attorney prepared him for this because this kind of legal tactic is really common. Employers will often try to get cases dismissed right out of the gate. But if you're going through something similar, don't panic. A strong attorney will expect this move and know how to respond. It's just one step in the process, not the end of the road. Okay, so the Higley Company also pushed back by arguing in court that even if medical marijuana is legal in Pennsylvania, that doesn't mean Davis is entitled to any kind of protection or accommodation under the Pennsylvania Human Relations Act, or PHRA. Their argument was that Davis didn't qualify for a disability accommodation because the PHRA specifically excludes protections for anyone currently using a controlled substance, at least under federal law. And since marijuana is still illegal under the Federal Controlled Substances Act, they claimed Davis wasn't protected. In response to the Higleys' request to dismiss the case, the court did in fact dismiss Davis's disability discrimination claim under the Pennsylvania Human Relations Act, or PHRA. They dismissed it in favor of the Higley Company. Why? Because the PHRA doesn't protect the use of medical marijuana or require employers to accommodate it. In making his ruling, the judge pointed out that the PHRA specifically excludes protections for the illegal use of controlled substances, and under federal law, marijuana is still considered a Schedule 1 drug with no acceptable medical use. So even if Pennsylvania allows medical marijuana, the PHRA defers to federal law, which means no federal protections, no legal protections for the use of medical marijuana. But not all of Davis's claims were thrown out. The court said his claim under Pennsylvania's Medical Marijuana Act could move forward because Davis didn't say he was fired for being impaired. He claimed the company acted against him simply because he had a legal medical marijuana card. And that's a different issue. So, what does this ruling actually mean? First, let's clear something up. Not all laws are the same. In fact, they vary a lot. Take Nevada, for example. In Nevada, medical marijuana card holders are protected. Now, employers there don't have to change the nature of the job or create special working conditions, but they do have to try to make reasonable accommodations, as long as those accommodations don't create safety risks or make it impossible to do the job or cause an undue burden on the employer. That's why, if you're a multi state employer, it is so important to know the rules in each state where you operate. Just because something is legal or not required in one state, that doesn't mean that the same thing applies across the board. And here's where it gets tricky. Using marijuana for a medical condition doesn't automatically disqualify someone from being considered for accommodations. Some employers think, well, the ADA doesn't require me to accommodate marijuana use, so I'm off the hook. But that's not always true. State laws might say otherwise, and even under the ADA, if someone has a legitimate medical condition, say anxiety or chronic pain, you still have to engage in the interactive process to figure out what, if any, accommodation can help, even if it's not related to marijuana use itself. Now, just to be clear, employers can still enforce drug free workplace policies, especially in industries that are federally regulated or involve safety sensitive positions. But in many states, including Pennsylvania, you can't discriminate just because someone has a medical marijuana card. That status alone can't be used as a reason to fire someone or pull a job offer that has been extended to a candidate. Now, I want to take a quick moment to put things in perspective. Davis filed his original claim back on November 14th, 2023. It took nearly 2 full years just to get his day in court, and a final decision has yet to be made in this case. And honestly, guys, this is not the longest timeline I've seen. Here's the thing. When you file a lawsuit, especially in employment cases, you have got to be ready for the long game. Court isn't fast, and a lot of people, they assume that once they file, a resolution is right around the corner, but that's just rarely the case. Depending on what you're up against, your employer might even use delay tactics to stretch things out. So it's important to know this going in. If you have a strong, valid claim, it's worth pursuing. Just understand the road to justice takes time. Now, if you're dealing with a marijuana issue at work, these next 5 points could make all the difference. The first thing to remember is that medical marijuana can still jeopardize employment. If you are a legal medical marijuana user, you can still lose a job. You can lose an opportunity. You can be terminated, depending on your state and depending on your job. Marijuana is legal under some state laws, but it remains illegal under federal law. So that matters. The second thing to remember is that employees have rights, but so do employees. Employers can enforce drug free workplace policies, especially in federally regulated or safety sensitive jobs. But in many states, like Pennsylvania, employers cannot discriminate just because someone is a registered medical marijuana patient. Legal cases that are being decided on the issue of medicinal marijuana matter. They affect how employment decisions are made in the workplace. Brian Davis's experience is an example of how a job offer was revoked despite disclosure and full transparency. The court allowed Davis's case to move forward under the Medical Marijuana Act, but not under disability law. So, this shows the limits of accommodations in the workplace involving the use of medical marijuana. When it comes to the use of medical marijuana and employment decisions, there is no one size fits all answer, and the outcome depends on state law protections, federal involvement, the type of job, and company policies. Employers should not assume that federal rules override state protections. Follow your policies, especially for hiring and discipline. And if you are an employee, you do need to disclose, but only when necessary. Understand your risks and know your state's law. The case of Brian Davis shows us just how complicated this issue can be. Employers are navigating a legal patchwork for sure, and employees are doing their best to follow the law, but they still face risk. And the bottom line is we need more clarity here, guys, and the law is still evolving. Both sides have to proceed with caution, with empathy and understanding. Now, if you found this video helpful, please subscribe and share with someone who might benefit from this information. And let me know in the comments, should employers be required to accommodate medical marijuana use? I'd love to hear your thoughts. Thanks for watching the HR Insider, and I'll see you in the next video.